Viewers, consumers are always intelligent, but the job of advertisements is to lure, draw, deceive consumers and potential consumers. This battle is never ending, but what if rules that were meant to protect you were dropped for revenues, leaving consumers absolutely unguarded with a heady mix of disinformation or partial information or misinformation and huge bucks exchanging hands at the back end? This isn't me making up a script. Today, the Supreme Court asked some very important questions while hearing Ramdev's misleading advertisements case. The court sought an explanation from Ayush Ministry for the sudden omission of Rule 170 of the Drugs and Cosmetics Rule 1945, which dealt with the power to take action against objectionable advertisements. A clause, by the way, that the government's expert body had recommended but was taken down by the central government itself. According to Supreme Court, now, what is this Rule 170 that the court has spoken about? It was meant to prohibit advertisements of Ayurveda, Siddha, Unani drugs without the advertisement being cleared by the licensing authorities of the state, which means that if you would not be cleared by the state's licensing authorities, you could not have these advertisements out. So it essentially meant to induce strong checks and accountability in place. After being pulled up by a parliamentary board panel for increasing misleading advertisements. Now, why was this removed? Here's an interesting fact. It was after the Ayurveda, Siddha, Unani drugs technical advisory board recommended for its omission. And this, despite an expert panel that had recommended for its inclusion and said that the omission was not required. Scores of manufacturers had moved Delhi court against this rule. Remember that. Scores of manufacturers. And the ministry eventually said they were doing away with this rule. Why this furor? And this is where it's very important for you to understand. We'll have experts to look into this. But this rule was a key aspect under Drugs Remedies Act or Consumer Protection Act that was preventive in nature, unlike the other sections, where the intent kicks in after a complaint was filed. It was this dilution that Patanjali used as an excuse to continue with their advertisements. The Supreme Court asked not just the centre but even the IMA if they were driven by just revenues. These advertisements take the public for a ride, particularly families, affecting their health. The issue concerns even the health of babies and school children. If that is happening, the centre has to activate itself, the Supreme Court stated. Now listen to this. According to data, the Advertising Standards Council of India has flagged 948 objectionable advertisements to the Ayush Ministry in the last 2 years. What happened to them? The court also, by the way, has asked this question. The Supreme Court has extended the ambit to misleading advertisements even in the FMCG sector, even as several brands have been under the scanner recently for products or claims, from Nestle Cerelac, Maggi to Bonvita, to the so-called healthy category drinks that e-commerce portals had asked to be delisted because the government said, the centre said that there was no definition of healthy drinks category as it were. But, by the way, the court has also drawn some scathing questions at the Indian Medical Association. Practices about doctors endorsing medicines in the allopathic fields, superinflated bills endorsing expensive medicines, and increasing complaints of unethical conduct of the IMA, putting the spotlight even on the petitioners who have taken on Baba Ramdev in the court, asking the IMA to put their house in order as well. All of this is going to come up in the court next on April 30th, with the focus on the centre and the IMA this time, even as Ramdev has assured that they will issue fresh apologies in proportion to the sizes of the advertisements earlier. After the court pulled them up today for the size of their apologies in the newspapers and the money spent compared to the advertisements earlier. And that's on your screen. The small white column are the apologies that have been issued. The yellow is really the advertisements in the past. While the court is going to look into so many more aspects, and hopefully a lot of information that we as consumers should be privy to will be out and open even as the hearings proceed in the court, some very, very important aspects. I've got experts to try and understand and help my viewers and me to understand better the issues at stake. I'm being joined today by Dilip Cherian, who's the founder for Perfect Relations, Acharya Manish, founder for HIMS, as well as Dr. Ishwar Gilada, the infectious diseases expert and Secretary General Organized Medicine's Academic Guild, and Pratik Som, who's an advocate with the Supreme Court and national spokesperson for JJP, also has argued for the government in several cases. Thank you very much, all of you, for joining. Very good evening. To you, Dilip Cherian, first, if I may. Could you help us understand what are we really looking at? Why was this very important section, seems to be the 170, that was diluted? It was brought in to ensure that consumers could be protected from misleading advertisements, and then it was withdrawn for no known reason that we can fathom. Is it correct that that was the only section that could be used in a preventive manner, and the rest of everything kicks in only after the advertisement is on screen, on your newspapers, whatsoever?
Your guess is as good as mine. But my assessment, based on how I've seen the industry evolve, is that it's in the interest of government to pretend that it is because of the pressure from industry. Now, where there are pressures from industry, government knows very well how to withstand it and how to ignore it. But in this case, it looks like a marriage of convenience. The government has diluted this and has also been totally aware that it is leaving a barn door of opportunity around for all kinds of companies to drive through it. So I think that it's been wrong. I think it's been done in a hurry. And I think it's being done with the internal excuse that this is to encourage industry to increase production, to allow investment, and a whole other bunch of baloney.
Dilip Cherian, one more question. And there's a statement that came up in the court today that over 900 cases of misleading advertisements have been flagged by the Advertising Council to the Ayush Ministry. Now, what does this mean? After it is flagged, what really happens? Do we know? What happened to these cases? Was it taken off? Were the companies fined? Did anything happen? Do we know?
Pathetically little happens. Having been on the ASCI for 2 terms, I recognize that ASCI, which is owned and run and led by advertising agencies, is willing to stand up and blow the whistle. But does it have a club to clobber these misleading ads? The answer is no. If the companies go ahead and use the agencies and put out the ads, there's pretty little that they can do about it, except say that, in the future, we're going to do something to them. To my mind, it is a self-regulating business, but with very non-existent teeth, actually. And there have been complaints. The board has been saying that you need to be able to deliver punitive justice. And unless you have the ability to stop both the agency and the client company in its tracks, you will never be able to rectify this in any self-regulating manner. Can the court step in? They can. Will it delay things? It will. Can ads be checked? before they are put out. I think in many product cases, they ought to be. I've been a votary of trying to allow the markets self-regulate, but I think that we are now living in very dangerous times there.
Right. Dr. Ishwar Gilada, my first question to you, with what's unfolded in the courts today, there are so many questions that are emerging, but also this whole cahoot that the court has really mentioned about. One being about how there seems to be the government and certain wings of the pharma that seems to be working together. There seems to be no accountability. There's nobody to watch anybody's back. Everybody, particularly the consumers, where the children, where school-going children, where babies are hit. Of course, they were talking about the FMCG sector controversies that have recently happened, but also drawing in the medicines, the allopathy, as well as, of course, we are seeing the whole controversy with Baba Ramdev and Patanjali, and just the lack of anything that functions as a guideline or a regulatory body. This is a complete collapse in all its senses. And from food to medicine, where does one really go to? What does really one do as an ordinary consumer?
Thank you very much for having me on the show, Sneha. It goes back to almost 40 years when the commercialization of medical education started. When the commercialization started, we opposed tooth and nail. At that time, out of 106 medical colleges in the country, only 6 were private medical colleges, 100 were government. Today, there are 750 medical colleges. Only half of them are government, half of them are private. And the seats in private colleges are more. Number two, most of the hospitals are run by business community. They are not run by doctors. Number three, there is definitely a code between pharma companies and doctors. But who is to be blamed? Because if suppose for continuing to be a doctor, I need to collect 30 hours of kind of credit hours in 5 years. That one credit hour is equal to 4 hours of teaching. Now, if government of India, government of Maharashtra, or any state government or medical council do not make any arrangement for continuing medical education, the doctor will fall back on pharma companies. Pharma companies will have incentive. Incentives will have link with alcohol. We opposed 20 years before that there should not be any alcohol served in medical colleges, medical conferences. I was the first person to do that in India, but I was opposed by my own community. Now that has become a norm. So I think it is a kind of a business rather than a profession. And in profession, that nobility is being lost. So I think it's a good thing that the discussion started, and it should not stop here. There is a lot of cut practice which is called commission under table.
It's not about nobility. That nobility is, it's a word that itself kind of, it doesn't exert any accountability. Nobility means that, you are somebody who's great doing a very noble cause. It's not really a noble cause. You're meant to do a job that is already done. And quite frankly, it's not being done in this country. Acharya Manish, if I can come to you at this point, huge observations by the Supreme Court that really come across for the not only the center, but also practices that are very endowed even in the sector that you represent at this point. Whether it be what we have been seeing in the Patanjali case, look at the apologies that have come in, look at the statements, how the Supreme Court has had to pull up Ramdev several times in the court. And finally, there seems to have been an apology that is in place. Rules and regulations were openly flouted. And look at the endorsements that have come in from all places, the advertisements, the claims that are there. Isn't this just raking up? And what the court has said, isn't this just raking up for revenues?
मैडम, मेरे हाथ में ये 1954 का मैजिक रेमेडी एक्ट है। ये इसमें साफ साफ लिखा हुआ है कि कुछ बीमारियां हैं जिनका क्लेम नहीं किया जा सकता। लेकिन मैं एक सवाल पूछना चाहूंगा, इसमें फीवर को भी जोड़ दिया गया है, जबकि हिपोक्रेट्स जो कि एलोपैथी के जनक थे, उन्होंने बुखार को हमारा मित्र बताया था। हैनीमन जो होम्योपैथी के जनक थे, उन्होंने भी बुखार को हमारा मित्र बताया, और आयुर्वेद में भी बुखार को हमारा मित्र बताया। लेकिन इसमें अगर हम कहेंगे कि बुखार दवाई से ही ठीक करना चाहिए, तो वो भी गलत है ना। तो जो मिस एडवर्टाइजमेंट है, जो आप बात कर रहे हो क्लेम्स की, तो सारी की सारी कहानी है गेन्स की। जो मार्केट में लोग प्रैक्टिस कर रहे हैं, डॉक्टर्स प्रैक्टिस कर रहे हैं, वो एक मतलब एक गेन लेना चाहते हैं, एक पैसा लेना चाहते हैं, तभी तो वो ऐड करते हैं, चाहे वो बॉर्नविटा आप दिखा रहे हो,
तो आप
चाहे
भी
स्प्राइट की
गेन
ऐड
ले
दिखा
रहे
रहे हो
हैं।
आप।
तो
सब
इसीलिए सेंटर ने भी कंज्यूमर्स का पूरा तमाशा बना दिया।
नहीं, वो तो देखो सेंटर का मामला है। मैं तो आपको एक, अगर आप बोलो तो मुझे परमिशन दो,
तो
तो 2000
आपका क्या
में
मामला है
एक
सर?
इकोनॉमिक टाइम्स में एक रिपोर्ट छपी है, वो बताना चाहूंगा कि पीठ, कमर और रीढ़ की हड्डी के दर्द के कारण अक्सर रहस्य में होते हैं, मतलब पता नहीं चलता, और इस कारण अमेरिका में हर साल 6,25,000 करोड़ रुपया खर्च होता है। और जबकि अमेरिकन बीमा कंपनी सिग्ना ने बताया कि रीढ़ की हड्डी घिसने के बाद सर्जरी कराने वाले 87% लोगों को आराम नहीं मिलता, लेकिन उनकी सर्जरी
Sir,
होती
this
है।
is not,
जबकि
no, I'm sorry, sir. No, you cannot take excerpts of medical reports. You cannot take excerpts of findings, particularly from the medical board, medical division. I don't know the head and tail of what you're talking. We don't know the history of the patients. We don't have any papers and documents with us. This is propaganda. This is misinformation. I can't allow this on air, sir. I can allow you to
नहीं,
talk
मैं
about
तो
the
आपके
gains. I
सामने
can allow
इकोनॉमिक
to
टाइम्स की
talk
रिपोर्ट
about
पढ़
the
रहा हूँ।
revenue mentality, but I cannot allow. No, it doesn't matter. I don't have that report. I do not endorse every report. I don't know what kind of a
नहीं,
report
मैं
that
तो
is. This
कह
is
ही नहीं रहा,
not
आप इस
something.
रिपोर्ट
You
को
did not
मानो।
send it to me to vet this. No. No, this is not something that I've asked you. This is not the answer to it. Acharya Manish, आपको जो आंसर देना है, आप प्रश्न का उत्तर दीजिए ना।
मैडम देखो, ना तो मैं टेक्निकल पर्सन हूं, ना मैं कोर्ट की प्रोसीडिंग के बारे में कुछ बोल सकता हूं। मैं तो आयुर्वेद के बारे में बोल सकता हूं कि आयुर्वेद कैसे काम करता है और मॉडर्न
So
कैसे
the
काम
big
करती है, और
question on
मिसलीडिंग एड तो
Ayurveda
दोनों ही।
है कि why did manufacturers, including those from Ayurveda, rush to the court when there was a regulation, when there was a rule of 170 that was introduced, that was
मैडम
supposed to be ensuring that states had licenses? Why did even Ayurveda manufacturers rush to the court against rule number 170? ये तो आप मुझे explain कर पाएंगे?
देखो मैम, मैं तो इतना जानता हूं कि 1954 का रेमेडी एक्ट ही गलत है। ये पूरा का पूरा एक्ट ही अंग्रेजों ने बनाया था 1930 में, कमेटी बनाकर अपनी पैथी को स्थापित करने के लिए। जब एक चीज की स्थापना ही तब हुई जब भारत गुलाम था, तो वो एक्चुअल में सही कैसे हो सकती है? तो ये सारे एक्ट, ये जो आईएमए की बात भी करते हैं, तो
Dr.
आईएमए भी
Ishwar Gilada,
1948
do you
में
want
बनी
to
है, अंग्रेजों ने
respond?
बनाई थी।
Dr. Ishwar Gilada, do you want to respond to what he's saying? He's saying that the entire 1954 Act is wrong, and I'm coming to you for this question. I mean, this is the problem. We can't just be making these loose statements. But what Acharya
मैम,
Manish has really said is what even Ramdev and his team, in fact, is what the Ramdev and his team has also argued in the court. And the fact that this rule 170, which is a preventive measure that was there introduced in this 1954 Act, was diluted, is the very reason that they are using as an excuse for those advertisements that they eventually launched. So where is this game stopping?
No, Magical and Remedies Act has been in place and it is very much important. In medical science, we believe in Koch's postulate. If you find a result with medicine in one patient, you should be able to find similar result in thousands of patients. If you do not find, that is called magical remedy. So I think what Acharya is saying is wrong. It is nothing to do with British ruling India. It is nothing to do with anybody will say that I have done this thing, I have taken 2 mantra and my disease has gone. But we have to reproduce that in thousands of people. So if that is not done, it is magical remedy. And in India, there are all the pathies are there. Ayurveda, Siddha, Unani, naturopathy, urine pathy, snake venom pathy. So people will claim anything that I have cured this person with this. You cannot take this as a science. Medical science and hypocrisy, they are totally opposite.
सर भारत में पैथीज बहुत सारी हैं, लेकिन
Acharya
उनकी
Manish,
वैल्यू
I
क्या
also
है?
have to. नहीं, रुक जाइए. नहीं, my question, Acharya Manish ji, if you are even calling an existing act as hypocrisy, then how does one anyway regulate you? Everybody has to be regulated at some point, but if you're calling the disdain, तो क्या हुआ?
तो मैडम
सब
अगर
लोग
कोई चीज
उससे
गलत
regulate
बनी
हो
है
रहे
तो
हैं
उसको
ना
सही
अभी।
भी तो करना चाहिए ना। तो मैडम एक चीज, अब भारत सरकार ने कितने
क्या
कानून
गलत
पुराने
है उसमें,
खत्म
यही
किए ना
तो
अभी।
समझ।
एक बात बताओ मुझे, एक मैं बोलूंगा एक लाइन।
See, Dilip
2023
Cherian,
में
let me
भारत
get.
सरकार का टोटल बजट 86,000 करोड़ रुपए है हेल्थ पे, उसमें आयुष का बजट सिर्फ 3700 करोड़ है। कहाँ 5 पैथियों को 3700 करोड़ और कहाँ एक पैथी को 86,000 करोड़ रुपए। तो मैडम इस देश में आज भी तो आयुर्वेद वर्सेस एलोपैथी तो चल ही रहा है ना। और ये शुरुआत कहाँ से है? 1928 में आईएमए की स्थापना हुई है,
Sir,
1930 में कमेटी
Ayurveda
बनी थी।
versus allopathy है ही नहीं. I mean, no, I don't want to get into this. This debate is not about Ayurveda versus allopathy. That itself is wrong. If you are saying this coming on this show, that basis, इसका मतलब यही है सर कि आप डिबेट को समझ ही नहीं पाए हैं. और
मैडम,
मैं
ये
आपको ये
पोस्ट है जो
डिबेट
मुझे
डिरेल
आपने
करने
भेजी
में
है।
नहीं दूंगी. ये
ये
एलोपैथी
पोस्ट
वर्सेस
है।
दिस.
मैडम चेक करो, ये पोस्ट मुझे बना के भेजी आपके चैनल से, आयुर्वेदा वर्सेस एलोपैथी। मैं क्या करूंगा, एड
This is
के बारे
not
में
Ayurveda
मिसलीडिंग है तो
versus allopathy.
डिपार्टमेंट देखेगा।
पर ये misleading advertisements थे कि नहीं? Were they misleading advertisements? Do you agree that there is no check on misleading advertisements? Is that a concern that you all also have? चाहे वो किसी भी विभाग से हो, advertisements regulate नहीं हो रही हैं इंडिया में. Is that a concern you have?
वो होना चाहिए, उसके लिए डिपार्टमेंट बना हुआ है, वो अपना काम कर रहा है। न्यूज चैनल पे कौन चेक कर रहा है मैडम? न्यूज चैनल भी तो पता क्या क्या फैला रहे हैं। उसके लिए भी डिपार्टमेंट चाहिए कि कौन सी खबर जानी चाहिए, कौन सी खबर नहीं जानी चाहिए। वो तो इंडिया में कानून है, अपना काम करेगा। मेरा जस्ट ये कहना है कि जिस कानून की शुरुआत ही इस सोच के साथ की गई कि आयुर्वेद को खत्म करना है, उस कानून के आधार पर आप मिसलीडिंग एड और ये सब जब बोलोगे तो फिर आपको एक्ट भी तो समझना पड़ेगा वो लाया क्यों गया था, अंग्रेज क्यों लाए थे। 1946 में भोरे कमेटी बनाई थी।
Here's a big challenge. Here's a big challenge, Dilip Cherian. You've heard Acharya Manish speak, and they are very much questioning the very essence of what is being regulated. The foundations of what is the regulation in India is being questioned. In that case, where does one have any regulation if you don't have teeth to control it? It's basically consumers left to fend for themselves.
Sneha, it's a good question. And I think that what the Acharya is trying to link is the fact that he and practitioners of his art believe that it's got to do with nationalism of some kind and less to do with health of any kind. The facts are very simple. There are a whole bunch of tests, there are a whole bunch of regulations in place, not necessarily to do with the Magic Remedies Act. That is a what I would call a red herring. The idea is that many products, and getting into Ayurvedic products is a self-defeating trap. If you look at products like Horlicks, if you look at products being sold for sleep, products being sold for back pain, it is quite clear that there is no body of actual medical research and evidence. Today, the world relies on that. It's got nothing to do with colonialism, nationalism, nothing of the kind. It's got to do with human beings who are affected badly, who pay big money and don't get the results they expect. It's as simple as that. Anything which tricks them into spending their money for a cure that does not work for them is something that needs to be banned.
Pratik Som, how do governments at this point look at these issues? Are these things that are taken up legally? Is there a legal recourse to this? Do states and state governments, I'm asking you this because you've been a state government leader as well, do they legally take recourse to such actions? Is there action taken for such violations? Are they considered as violations at all? Are they looked at all?
Yeah, just give me a patient hearing to understand where this case is and what all has happened so far in the case, the role of central government and state governments are concerned. First of all, I think this case is now not only about Patanjali or Baba Ramdev. It is more about the broader concern on the public welfare against the misleading acts. Now, we are discussing today on Rule 170. Now, let me give you a clear picture what has happened, what is the legal position. See, central government is a policy-making body. It is not an action-taken body. It is not a body which penalizes people who do misleading acts. Now, what has happened so far? This act has come in 1954. Thereafter, in 2018, my point number one is that central government notified amendment of drug and cosmetic rules in 2018. Now, what does this amendment says? It inserted Rule 170 specifically for controlling inappropriate advertisements of Ayurvedic, Siddha, and Unani medicines. Now, thereafter, what has been done? Ministry of Ayush signed a MOU with Advertisement Standing Council of India to take the complaints and refer it to state governments for taking action. Now, thereafter, as a result of this MOU, 732 cases of misleading advertisements of Ayush were reported in 2017 and 18, and then in 2018-19 there were 203 cases. But what central government can do is that they can escalate these cases to state government, which further will direct the state regulators to take action against these violators. Now, the state and union territory authorities have been directed for appointing gazetted officers under Section 8 of Drug and Magic Remedies Act of 1954, which they have done. Now, these centers for Ayurveda, Siddha, Unani, homeopathic drug setup, they are set up in different part of country under the central scheme of Ministry of Ayush. They are the funding agency, they are the policy making agency, but they are not the action taking agency. This is the one broad category which I am trying to put in. Give me one more minute. Now I am trying to say that the action against any of these violators will have to be taken by the state regulators, not by the central government. Central government has already notified through this amendment that we have signed an MOU, we have created a platform, you can complain over here. This complaint will go to state regulator. If a state regulator is failing, that court will see. Now, Sneha, I think it's a pity that such kind of people, and I will not shy away even saying that one of my co-panelists, you are calling him on national media where he says, that this act has come during, Britishers' time. This act has been introduced 1954. I have personally seen videos where this fellow has told that if a dog bites you, you don't need to do anything. Dr. Gilada can give a light on it. A person may die, but such kind of claims are coming on social media. This is the most unfortunate
but now
part.
that you are saying this, let me just tell you, because you have made this. Hold on. 1 minute. Pratik, one thing at a time. One thing at a time. Pratik, one thing at a time. Since you have made that statement, I have to come up and say, Pratik, hold on. Since you made that statement, it's very important for me to say that that's a misinformation that is propagated by certain groups, including, as you have claimed, Acharya Manish. Now, why I've called him here is to represent a group that he will not peddle any misinformation on this channel is my job, and I will do that very responsibly. Any misleading attempt will be counted by me. I have not taken his history. Hold on, I will come to you. Pratik, let me give you a very solid answer. I will not allow him to peddle lies here or fake. And I countered him the moment he tried to say that. And there are all other panelists to take that on as well. But let me come back to the very important point that we are really talking about here. And Ishwar Gilada, let me just bring this to you at this point. Let's look at some endorsements that the IMA has also done. And I'm not going into the rights or the wrongs. Look, some of them, like you've had Tropicana fruit juice, Quaker oats. You have another thing that seems to be Crompton Greaves, where it's certified anterior bacterial lead bulb. You have Dettol, which is videos aired by Ricket Show, IMA stamp of approval. You have Kent as well, Asian Paints as well. The claim is protection from viral transmissions. So these are also some claims, these are also some endorsements by IMA. Again, the whole thing that's before the court today is again about revenues, is about endorsements. So while we may say it's a huge revenue at stake for one side, that is the Ayurveda, Unani, or whatever systems we are talking about, Patanjali being in court, the other system here also being IMA and the endorsements that seem to come from there. Is that also a concern?
Sneha, just because I'm a medical doctor, I'm an Ayurvedic doctor, I'm not going to endorse whosoever is doing wrong. If something is wrongly done, that has to be condemned. Whatever endorsement has to be done, it has to be done with research, with some kind of consensus. You cannot do the endorsement for the sake of some monetary gains. So what is wrong is wrong. Whether IMA has done, whether somebody has done, that is wrong. So I'm not going to endorse if something wrong. And I'm with the Supreme Court finding if something wrong is done, that should be punished, whosoever it is, that person.
No, so what I'm trying to understand at this point is even endorsements by IMA, endorsements like this, is it a concern medically? Is it a concern internationally? Are these, I may not want to use the word lobby at this because I don't know enough about this, but are endorsements like this, apart from being huge revenues, also something that could be extremely misleading as well?
I think one should not go into the domain which we do not understand. If we do not understand paint, we should not endorse.
Right.
If we do not understand any kind of thing, we should not endorse. So, and having said that, we need to create a kind of a parallel machinery where we have a health science communication, educating people. And that is the most important thing because now it is, earlier it was very difficult. Now it is, you click of a mouse, people can be educated. So I think we should educate people. They should understand what is right or wrong. For example, a cost of a medicine, same molecule can be for 10 rupees and 100 rupees. But let people be educated that go on the net, see that molecule on different medical sites, and if that molecule is from A company for 10 rupees, B company for 100 rupees, don't buy 100 rupees one. At the same time, the government also should act that they should not keep a buffer margin. If there's some price which is required for manufacture, keep 100%, 200% margin. You cannot keep 1000% margin. So there are different machineries to act. And I think this is a very wide subject, but we need to keep on educating masses because it is the human being which is at stake. And that needs to be understood properly. And whether medical community, Ayurveda community, government or any machinery, they should safeguard the interest of human beings.
Including IMA possibly, and of course as things unfold in the court, that's also something that's going to come up in the ambit of arguments. To you back, Dilip Cherian, at this point. Dilip Cherian, what we have been seeing even with IMA for that matter, and this whole equation of what seems to be unfolding vis-a-vis even medicines or food, it's just such an unregulated sector when it comes to advertisements and could you just help our viewers to understand what's the kind of money that we are really talking about? Because for some of us lay persons, it might just be even baffling to just kind of fathom the kind of money that would be involved in an advertisement like this, vis-a-vis whichever lobby it be, whichever body it may be that is endorsing Ayurveda, Ayush or IMA or whatsoever. What's the kind of money that's involved? Even the court is asking, is it about revenues? Just how crucial are these aspects?
Sneha, I think it's fairly easy to look at this as a problem with advertising. In my view, it's a problem with producing. Hundreds of crores of advertising revenue are used to sell products which should never be made. Meaning it's like saying I'm banning the advertising of cigarettes. But if you are endorsing the manufacturing of cigarettes merely because you get excise revenue from it, trying to choke it off with not allowing advertising is, I would say, a partial solution to the problem.
You know, the problem, but Dilip Cherian, is the example that you have used is a negative example. The endorsements that are done often are not necessarily negative. They could have positive aspects, they could have negative aspects, but they're not necessarily negative endorsements. You know what I mean to say? So in those cases, then how does one really turn to be discerning if they're actually being endorsed even by medical bodies for that matter?
Medical bodies are not saints. They are also susceptible to all kinds of influences. Should they be? No, they should not be. Are they open? No, they are not. Are their elections, so fair and square that those with vested interest don't get to those positions? The answer is there is a well-recorded history of the miscarriage of the whole process by which IMA and many other bodies are being run. So I think that trying to shift the blame to FSSAI, IMA, etc., is, to my mind, a sign of the frustration that all of us as citizens and as non-experts are facing. It is not rocket science to be
Okay.
able to allow a bunch of well-qualified scientists to say that this product causes harm. You made the point about endorsements of a positive kind. Sure, if the product is positive, endorsements of a positive kind must and should exist. You're asking a question of numbers. I would say the advertising industry in India, as far as these products are concerned, would be a couple of thousand crores. And the fact is that this couple of thousand crores is backing up an industry which is worth about 8 to 10 times that, if not more. So you're really talking of a percentage of that product, a percentage of that advertising, which is misleading and worrying for all of us as consumers. As Advocate Som
Right.
was saying, the law has loopholes. The law is not as old as the Acharya is saying. And if we want to change these things, the reasoning has to be better scientific evidence and not weaker regulatory mechanisms.
I think both are hugely important. Prateek Som, if I can just come back to you and very quickly at this point, one answer from each panelist at this point. Prateek Som, the court also spoke something very important, and that is about IMA's exorbitant bills, endorsements of medicines. So it's not just what the Ayurveda or the Unani or the other alternate forms of practitioners, what do they do? But it's also about IMA. Now I'm asking you again from a government's point of view. How often do you really see governments question, pull up, send notices that why are the bills so exorbitant? We had COVID, skyrocketed, prices skyrocketed. It's, you may say public, private, whatsoever. At the end of the day, they are hospitals, and this obviously has gone to the private hospitals. Skyrocketing bills in times of crisis, in terms of emergencies, that's a very normal thing. There's been no regulation, no broad basing, but being a government leader, have you seen cases where states have intervened? Has it even happened ever in your time?
Yes, yeah, so this something has significant happened today where IMA, which is a complainant in this case, has been put to notice by Honorable Supreme Court that how many complaints they have received against practitioners who charge exorbitant rates, and also they need to explain what action they have taken. So the court has also put the complainant in the dock that they need to now come, they are under notice, and explain. See, I accept the fact there is a loophole in the system. The law is not robust. And IMA, if operating, I think, in my personal opinion, it is operating without its teeth and its mind. So that is how this system is unregulated. But as far as other fields like misleading claims on the advertisements and all are there, the central government is very robust in its place by putting a policy and directing the states. See, it is our constitutional framework where the ministries at the center decide the policy, then they give the funds to the state and states implement it. That is what happened in this case also. In 1954, this act came. Ayush Ministry made an amendment in 2018 by inserting rule number 170, which created a framework where complaints against misleading acts can come. They funded the states. State, through its state regulators, is bound to take actions against the violators. So this is how it should be done. But IMA today has been put to notice by Supreme Court to explain that what action they have taken against the medical practitioners against whom the complaints have come. This is the position.
Ishwar Gilada, do you want to respond to that as well? Because, we have had several complaints, we've had several instances where there have also been spotlights on hospitals, on IMA for what seems to be exorbitant bills in times of crisis, in terms of health crisis for families, absolutely exorbitant bills. There have also been official complaints, cases before the courts about how certain brands of medicines that may be hugely expensive and of course being referenced by the court again have been endorsed in comparison to what the other brands or other alternatives might be. Again, guidelines exist within the IMA, but who really ensures that this is being followed?
Sneha, is that question to
Dr.
me?
Ishwar Gilada, this question is to you. No,
Yes. Okay.
Dr. Ishwar Gilada, that's question to you.
Okay.
Yeah, thank you. So sorry, I missed. You are saying that the IMA guidelines are followed by IMA people or not? Basically, one good thing
Yes,
today
I mean, there are
has been-
guidelines against these exorbitant bills, but who really sees that it follows through? Because we see complaints every now and then. There are headlines that hit about these exorbitant bills. It's all over social media. How does one really save oneself against this?
No, there are remedies available to people which are aggrieved. There's a Consumer Protection Act, COPA. There are legal remedies through police. There are legal remedies to medical councils. So they can, one person for one reason can go to all three different remedies. But there are a lot of people who do not want to fight. Many times we say that something has been wrong done to you, fight. They said, no, हमारे तकदीर में जो था हो गया. So I think that's the reason I've been saying that we must educate people about their rights, about their consequences, what are happening. Today, one good thing has been done by the Honorable Court. They involve Consumer Affairs Ministry and INB Ministry. So I think any kind of ad comes, I think every sentence should be seen. What is the backing of that sentence? From where did you get this? Are there any researches done on that for endorsement? Whether it's endorsement or any kind of claim that Asian paint kills the virus. So you show the research, where the research is done. So I think by involving multi-sectoral agencies, things will be better. And I think something will be better than today. I really admire your channel that despite election fever everywhere, you have taken this issue very seriously. Not all the channels have taken. So I think this is required that people should have a people's moment. It is not IMA, it is not Ayurveda, it is not one particular person. This is human life.
Right.
We should also give
True.
a lot of importance to human life because it's a very precious life.
Absolutely no, but thank you for acknowledging that. Mr. Acharya, if I can give you 30-40 seconds, मेरा प्रश्न आपसे ये है, आप जिस विभाग को represent करते हैं, क्या आप ये मानने के लिए ready हैं कि आप लोगों के ऊपर regulations जरूरी हैं, advertisements के ऊपर जरूरी हैं, उनको filter करना जरूरी है और regulation बहुत ही ज़्यादा जरूरी है हर विभाग के लिए?
नहीं, ये तो एग्री करूंगा ही मैं कि रेगुलेशन सबके लिए जरूरी है और फॉल्स क्लेम नहीं करने चाहिए, लेकिन फॉल्स इंफॉर्मेशन देना भी गलत है, जो कि पिछले 75 साल से दी जा रही है. जैसे कि एक नाम है एमबीबीएस. अब एमबीबीएस बोलते हैं, लेकिन डिग्री का असली नाम बीएमबीएस है. तो इसको आयुर्वेद की डिग्री जो बीएमएस है, होम्योपैथी की बीएचएमएस है, तो एलोपैथी वाले एमबीबीएस क्यों लिखते हैं?
I am not getting into this. Acharya ji, Mr. Manish, मैं आपको, I have given you time. I have not given you time for propaganda, Manish ji.
नहीं मैम, मैं बोल रहा हूँ फॉल्स इन्फॉर्मेशन भी क्यों?
I am not going to give propaganda.
जब कोल्ड ड्रिंक के ऊपर छुपाया जाता है चीनी है, तो एमबीबीएस वाले बोले ना हम बीएमबीएस है. क्यों बोलते हैं हम एमबीबीएस है?
All right, if that is your response, I'll just leave it at that. Dilip Cherian, last question to the audience, to the consumers who are watching you. Just 30 seconds if you would want to make your last remarks.
I think the point that we need to all have unity on is that at the end of the day, the consumer is king. The price they pay must be a justifiable price. The science they promise must be a provable science. The remedies they offer must be replicable with multiple patients. And most importantly, if you are caught trying to advertise something that does not meet these basic standards, you need to be shut down. And that is the kind of regulation we need.
Absolutely. Absolutely. Dilip Cherian, Mr. Manish, Dr. Ishwar Gilada, as well as Prateek Som. Thank you very much all for joining us, for bringing in your perspectives. We just hope that India will grow to a more transparent, more regulatory approach, particularly when it comes to guidelines for food and medicines directly linked to consumers, including children. All eyes in the next hearing in the Supreme Court. Thank you very much for joining us.